We finished discussing criminal act. Now we have to turn to the second element of a crime, which is criminal intent, or the mens rea. And it is the state of mind, the mental mind. Mens rea means guilty mind in Latin. Usually you need at least knowingly. They're aware, a defendant is aware that they possessed or controlled an item or acted in such a way. They know. That's our low level, but we'll get there. Criminal intent, state of mind, and it will be provided in the criminal statute what the intent element is. And it'll also define the meaning. And what it does, the state of mind, when we go through them, is going to determine what the level of culpability is. Basically, the responsibility, the accountability for the fault or the wrong. So say, for instance, a person is guilty of murder, the first degree, when with intent to cause death of another person. The question is what intent? In New York, I told you there's over 50 different statutes involving homicide. How do we get there when if you kill someone, you kill someone? Now, how do we get to 50 plus some odd statutes? Well, it turns on the level of culpability or the state of mind of the person. It may also depend on who that victim is. So one of the assignments that'll be when we talk about homicide is I'm going to have you pick one of those statutes and dissect it and interpret it. So, but nonetheless, primarily it turns on intent. So what does intent mean? One of three things. Meaning of intent. Our top one is malice aforethought. Our second one is specific intent. You have to intend to bring about the result. Sound familiar? Like a result crime, consequence crime. And then general intent. You just have to have intent to act. Hence our conduct crimes. So if we're looking at a consequence crime, we're dealing with specific intent. If we're dealing with a conduct crime, we are dealing with some level of general intent. And these are ranked based on culpability. So the worst accountability, or your level of culpability, hence which is going to result in your punishment, malice aforethought. The second highest will be a specific intent crime, and then the third will be a general intent crime. Let's start with malice aforethought. What is it? It's only used in one crime. Can you imagine which one it is? Murder. The intent to kill. Murder. And that is, so malice aforethought is a premeditation or predetermination with this term called malice, required as the element of this crime. It's used not to mean annoy or vex, or that it's not even hatred towards the victim. Malice exists when the defendant desires the victim's death, or is totally indifferent to whether the victim lives or the victim dies. Malice is only apparent in three types of criminal homicide situations: where the defendant intends to kill the victim, the defendant intends to cause serious bodily injury to the victim, or the defendant has a depraved heart and does not care if the victim lives or the victim dies. So malice aforethought is a term that came out of the common law, and you need premeditation and malice. And we're going to go into specific examples of this once we learn more of the intense thought processes or the mental states of a defendant. So the first one in our first category was malice aforethought. Our next one, we're going to talk about the differences between specific intent and general intent. And I will say one more thing on malice aforethought is that New York doesn't use that terminology. they will have it defined specifically by a mental state. And I'll show you some statutes. Specific intent. You recall our consequence versus conduct. I kind of just went over that a couple slides ago. I won't rehash it for you. We'll jump right into specific intent. It's the highest level culpability for crimes other than murder. New York uses this for their murder statutes. They'll specifically say the level of culpability. The statute isn't going to tell you exactly whether specific or general intent applies. You actually have to read it. The judge may even have to give the jury or the trier of fact the specific instruction or definition to it. Specific intent is the intent, like I said earlier, to achieve a specific result. A person acts, quote unquote, intentionally with respect to the result when his or her conscious objective is to cause the result. What the defendant intended is a question for a jury or a trial of fact, but the key here is they have to intend the result. They do have to do something more than the criminal act itself. And they have to act with the knowledge that that conduct is illegal. So let's kind of work through some of these examples. Actually, there's a couple good ones in the book I want to start with. They're easy enough, and then I'll kind of expand from there. So the first example, specific intent to bring about a bad result. Pauline says it's time to permanently mess up that pretty face, and thereafter takes out a razor and slices Peter's cheek with it. Pauline might be found guilty of the crime of mayhem. But on the other hand, if she slaps Peter while he's shaving without making the comment and the razor cuts him in the cheek, it's more hard to prove that she intended the scarring or intended the bad result, was what you need for a mayhem charge. That's not something we recognize in New York, by the way. Mayhem, we call it something else. Need to do more than the criminal act. So let's say there is a statute, a theft statute, that says the defendant must intend to do more than take property of another person. Let's say the defendant also, under the statute, must intend to keep it permanently. And Pauline borrows Peter's razor to shave her legs. Has she taken that property of another? She has. But she doesn't commit theft unless she keeps it. She intended to keep it or deprive Peter of his razor. If she intends to give it back, well, then you don't have specific intent to cause the result. Let's look at a couple more examples that I have here. How about this one? This is actually the assault charge for New York State, the highest level of assault in the first degree. A person is guilty of assault in the first degree when, with intent to cause serious physical injury to another person, and he causes such injury to such person, and they used a deadly weapon. Specific intent. It is specific intent, because what do you have to do? You have to intend to cause serious physical injury. If you don't cause, and you have to use a weapon, but we'll get there in a second, the intent is to cause serious physical injury. If you don't cause serious physical injury, then you don't have the crime of assault in the first degree. Let's do a couple more. Criminal mischief in the fourth degree, also a crime. This is a statute from New York State's Penal Code. A person is guilty of criminal mischief in the fourth degree when he or she intentionally damages property of another person. Specific intent crime. How do you know? Yes, it is. How do you know? Because it's a result. You have to intend the result to damage property. If you throw a rock at my window intending to break it, but you're a bad shot and you completely miss, you can't be charged with criminal mischief because you didn't break the window. Murder in the first degree. Top count, New York State. For murder, a person is guilty of murder in the first degree when, with intent to cause the death of another person, he causes the death of such person or a third person. We'll talk about transferred intent a little later. But here you don't see that term malice aforethought. You don't see premeditation, I should say. But is it a specific intent crime? It is, because you have to cause the death of a person. We'll flush out exactly what level of culpability or intent level. We're just being very general when talking about malice aforethought, specific intent, and shortly we'll talk about general intent. Something else that specific intent is, you have to do something more, like I said, do something more than commit that criminal act. Let's talk about burglary in the third degree. This is a New York State statute. A person is guilty of burglary in the third degree here in New York when he knowingly, that's going to be your first snapshot of some mental states as we move forward, he knowingly enters and remains unlawfully. Let's stop there for a moment. If you knowingly come into my house without my permission and you remain, have you committed burglary? Not yet. But if you go into, let's not call it my house, let's call it my shed, because it's in a building. It doesn't say in a home. Let's say it's my shed. And you unlawfully remain, you haven't committed burglary yet, because what do you have to do? You have to intend to commit a crime therein. So this is a specific intent crime. You need to do something more than commit the criminal act. The criminal act might be you knowingly entering and remaining in my shed. Unlawfully means without my permission. But that's not burglary. That might be trespass, but that's not burglary. Burglary requires a specific intent, and your intent is to commit a crime therein. So if your intent is to steal my lawnmower, then you've committed burglary. How about larceny? I just did a theft one with you from the book. This is the definition in New York, or this is the crime in New York. A person steals property and commits larceny when, with intent to deprive another of property or to appropriate the same to himself or to a third person, he wrongfully takes, obtains, or withholds such property from an owner. So if you take my property with intent to deprive me of it, never give it back, hold it, sell it, whatever, you have committed the crime of larceny. So if you are my neighbor and you see my shovel hanging out in my backyard and you need a shovel to dig a hole in your backyard, and I'm not around to ask for it, but you come on over and use it anyway, and you shovel out the hole and then you return it, did you steal it even though you didn't have my permission to use it? No, because you brought it back. It wasn't your intent to deprive me of it. There's one more type of specific intent, and that's when you have knowledge that your conduct is illegal and you do it anyway. And we call that term willful. When you willfully act, you're doing it intentionally, but you're doing it and you know it's illegal. Willful. Let's say, for example, statute makes it a crime to willfully file a false tax return. You know you have to file your taxes, but you don't, right? Willfully. Any person who willfully defaces any machine gun, large capacity ammunition, feeding device, or firearm is guilty of a Class D felony. So you are defacing, maybe taking serial numbers off, and you're doing it willfully. You know what you're doing is illegal. This is a statute in New York. Because why? I don't have any idea if you can own a machine gun in New York. I would think that falls under their SAFE Act, but I'm not a gun person, and I didn't prosecute any gun cases or defend any gun cases that I can recall off the top of my head that involve defacing any of the weapons. But certainly, if you are scraping serial numbers off a weapon, you know what you're doing is illegal, because that's how they trace these things. So you'll see willfully, and that is a specific intent crime. And they call that, it's in the book, scienter. It's another type of intent. You won't see that term in statutes. The term you'll see is willful. So the knowledge that you act, that the act you're doing is illegal, and you know it. So let's switch on over to general intent, which is easier to prove than specific intent. How does a prosecutor prove a defendant's state of mind? Kind of a recap. We talked about it last time when we were talking about evidence. Primarily, unless they have a defendant's confession saying that they intended to do that act, the only way that they can do it is by what kind of evidence? Circumstantial evidence. I heard you all say it to me. Circumstantial evidence, where they have to kind of put the facts together. I think the example that I used when we talked about it was the charge was assault, and right before the defendant punched the victim in the face, the victim said, "I hate you." Kind of shows that that was the trigger that caused the defendant to punch the person, or intended to cause the damage to the person. So, general intent. Intent to perform the criminal act. Another, like I said, how do we prove it? The same thing, by inference, but it's a lot easier to do. And this is the intent to perform that actus reus. The defendant acts intentionally, but without the additional desire to bring about some certain result. Drinking and driving, right? Somebody leaves a wedding, they've had a few drinks, they're driving home, and they're in an accident, and the driver of the other vehicle dies. When that person got in their car to drive, they didn't intend to kill somebody driving home. What happened was they voluntarily acted in driving after drinking and drove. So that doesn't mean there's no trouble at the other end. That might be something that falls in one of those 50 some odd statutes when somebody dies in a homicide case, but in New York. But DWI is a general intent crime, and the intent is you do the act of driving while you're intoxicated. How about the charge of harassment? I think I got it. Yep. The statute is one is guilty of harassment when they intentionally, harmfully, or offensively physically contact. They have intentional, harmful, or offensive. I didn't have anything to drink. Intentional, harmful, or offensive physical contact with another. Okay? That's our law of harassment. Is it a conduct or a consequence? I hope you're saying conduct, because it's a conduct crime, which means what is it? What kind of intent? Do we have general or specific? We have general. We don't have a crime here that requires some result. All we have is a act. So if Mark is in Andy's seat and Mark asks Andy to move and Andy says no, and Mark slaps Andy upside the head and calls him a stupid idiot, do we have a crime? We do. We have harassment. He may not have gotten a lump. He may have gotten a lump or not gotten a lump. What happened was he did an offensive contact. I'm sure Andy didn't want to get slapped upside the head, so it's an offensive contact. It's also a harmful contact. So You don't have to desire to bring about the result. You just have to be aware that you don't even have to be aware that any result would happen. That would be willful. You just have to have the voluntary act of an intentional act of a harmful contact. In this case, slapping somebody upside the head is a harmful and it's offensive contact. It has to be one or the other. It doesn't have to be both. I have the example up here on the screen if you are following along. Elonis versus U.S. I'm not going to go into that right now. This is a case that I had alluded to when we were talking about free speech. I said there might be a forum post relative to a internet threat and how that would play out. I think that issue and the one we are just talking about right now is this case. So it is part of this week's forum post or assignment. So I tied them in together, the two. So I will have you guys review that on your own as part of an assignment. Is intent motive? Is intent and motive the same thing? What is motive? Motive is the reason, right? Is the reason why we do something. We're motivated to do something. We have motive. It's the reason for our purposes here, criminal law. It's the reason the defendant commits the criminal act, right? The reason. Just because Robin Hood stole from the rich to give to the poor, do we let that go? He still committed a crime in my eyes. But the motive here, I'm losing my train of thought. Sorry guys. This is real. I can't go back and edit. Intent is not motive. Motive is the reason defendants commit a crime. Does motive matter? In some circumstances. Does the prosecution have to prove motive? No, they do not have to prove motive. However, if they have a motive that they can share, it certainly helps them tie their case together to allow the jury to do what? Make inferences. So if we're dealing with a murder and it was one spouse killing another spouse, and lo and behold, there's $1 million life insurance policy out on the dead spouse, well then, do you think the prosecution is going to be like, and they had a motive to get to kill their spouse because they're going to get $1 million policy? That's a nice little tie-in, but it doesn't have to be proved and it doesn't have to exist. Yet some people don't have a motive for committing a crime. They just commit crimes. And I know that sounds crazy because you would want to think that there's always some reason why somebody commits a crime. I mean, I've certainly represented people who have a motive. I've represented parents who stole food from the grocery store so they could feed their kids. Just like Robin Hood, but they still get charged with a crime. Do they get some leniency? First time around, there's extreme leniency. The case may even go away. 2-3 times, not so much. But there are folks who just do it. There are 4 states of mind. When we were talking about malice, aforethought, and specific intent and general intent, those were general terms. Now we're going to kind of put the specific states of mind, together. And the first one is purposely. Purposely means that a defendant intends to engage in the conduct and intends the result. This is the term that we are going to see relative to specific intent. And this is what's the model. These are the model penal codes, states of mind, also used in other states. New York uses them all except purposely. They call it intentionally. That's what they use interchangeably. But they don't use purposely. But for purposes of this discussion, Purposely means intends to engage in the conduct and intends the result. Specific intent crime. Knowingly is our next one. Indicates that a defendant is aware of the nature of the act and its probable consequences. How does that differ from purposely? The defendant is not acting to cause the certain result, but is acting with the awareness that a result is practically certain to occur. We'll do some examples in a minute. And recklessly means that a defendant consciously disregards a substantial and unjustifiable risk that the bad result or harm will occur, and negligently is acting grossly unreasonable. I'm going to go through these specifically using a statute for each one and some examples. So let's purposely. Intends conduct and the result. This is the New York culpability statute. They don't use purposely, like I said, they use intentionally, and this is the New York companion. A person acts intentionally with respect to a result or a conduct described by a statute defining an offense when his conscious objective is to cause such result or to engage in such conduct. So you still need both. You need the act and you need the result when we're talking about the term intentionally here in New York. Knowingly. Like I said, knowingly, the defendant is aware of the nature of the act and its probable consequences. New York has its own definition of knowingly. A person acts knowingly with respect to conduct or to the circumstance described by a statute defining an offense when he is aware that his conduct is of such nature or that such circumstances exist. And as I said, the difference between knowingly and purposely, what's the difference? Defendant is not acting to cause a certain result when we're talking about knowingly. They're just aware of the nature of the act and its probable consequences. So let's talk about a couple examples. Suppose that Peter Pumpkin has intentionally pulled the trigger of a gun and a bullet from the gun killed Lucy. If Peter is charged with purposely killing a person, the state would have to prove what? That he intended to pull the trigger and that he intended to kill Lucy. So you need the act and you need the result. Peter Pumpkin admits he pulled the trigger intentionally, so he intended the conduct, but responds that he is not guilty of the offense because he did not intend to hit anyone. He was aiming at the trees behind the 50 campers that are over there, and Lucy just happened to be standing amongst the campers who were just sitting around. She was standing up. What do we got here? Can he be charged with a crime? How did he act in this instance? Knowingly? Is that our word we're looking for? He intended the conduct. We got that. But knowingly, when he knowingly behaves, doesn't intend to hit anyone, that wasn't his intent to hit anybody, but can he be aware of the probable consequences? Yes, and he could probably be charged with murder in this case. How about stalking in the 4th degree? A person is guilty of stalking in the 4th degree when he or she intentionally engages in a course of conduct directed at a specific person and knows, or reasonably should know, that such conduct is likely to cause reasonable fear of material harm to the physical health, safety, or property of such person. Do we have general or specific? We have a specific intent crime, and we have our two states of mind. We have intentionally engages in our conduct, and they reasonably know that conduct is going to cause a harm. So far, so good. I wish you guys can ask me some questions. If you have any questions, just let me know. All right, let's try one more. A person under the New York public health law, a person is guilty of endangering public health and safety of the environment when he knowingly engages in conduct which causes the release of a substance hazardous to public health, safety, or the environment, and such release causes physical injury to any person who is not a participant in the crime. Do we have a general or specific crime here? It's specific. Because why? He knowingly has to engage in the conduct, and he has to know that the release of that will cause, and that he knows that releasing that will cause physical injury. We need two things here. Result crime. Do you see? Hopefully you're following me here, but we have two things that he knowingly has to engage in or be aware. Our next state of mind is recklessly. It's when you consciously disregard a substantial and unjustifiable risk that a bad result or harm, not of harm, or harm will occur. And you need two things. It's a two-pronged test. You need two things. You deliberately disregard a knowing risk of harm, and that there's no reason that exists for you taking that action. So the key is the degree of risk, the awareness. This is distinguished from knowingly, like practically certain. You know something is going to be bad. Shooting into trees where there's a bunch of campers that are standing around. You kind of know that's bad. It could also be recklessly too, right? Deliberate disregard, a knowing risk of harm, and no reason exists for you to be shooting a gun. Could be recklessly too. That example, Peter Pumpkin. What about you take the cops on a high-speed chase through the city, let's say through the city of Plattsburgh. There's things like all these little one-way streets, and you're going up and down them the wrong way. Is that reckless conduct? It sure is. Deliberately disregard a knowing risk of harm. What's the knowingly risk of harm? Running into somebody? If you're running through intersections, and there's no reason that exists for taking that, and not running from the police is one of them. That's not a good reason. How about Fred and Alan, who are staying at Alan's cabin in the woods for a hunting weekend? Fred falls asleep in a chair in the living room, and in an attempt to wake him up as a joke, Alan aims his loaded rifle at the lamp just above the chair and fires at it, but at the same time Fred wakes up and he sits up and the bullet strikes him in the head, killing him. Can Alan be charged with a crime? Can he be charged with like murder in the first degree, an intentional killing? No. Could he be charged with knowingly? Probably. It's probable that the consequences would happen. If Fred didn't wake up, he would have hit the lamp. I don't know if knowingly works here. How about recklessly? Does that work better? When you deliberately disregard a knowing risk of harm, the risk is Fred waking up, and if Alan wasn't a good shot, he could have hit Fred while he was sleeping. And was there any reason for him to take that risk? No. So yeah, Alan could be charged. Probably with some level of murder. Maybe not murder one, but some other level. Let's take a look at manslaughter in New York here. Manslaughter in the second degree. A person is guilty of manslaughter when he recklessly cause the death of another person. Oh, well, look at that. Maybe Alan can be charged under manslaughter in the second degree. Why? Because what's he doing? He is shooting his gun in a reckless manner, and he's causing the death of another person. So if he recklessly acts and the result, this is not a result crime, because he's not intending the result. He's recklessly shooting a gun that resulted in the death of another. This is a general intent crime. See the difference? So recklessly, I am not going to read this entire slide to you. You guys can read it. I gave you the shortened version, but it is a two-part test. And since I gave you what the that I gave you what the intentionally and the knowingly definitions were in New York, I want to give you the recklessly, and this is what it is in New York. And it's basically those same two elements that I have already discussed and said in a previous slide, so I won't stick around here and read it to you. I'll let you guys read it. Well, let's move on to the last state of mind, negligently. This is where there's a difference in the lack of awareness. You should be aware that a substantial and justifiable risk exists or will result, and that there is a failure to do so. This is less than recklessly, that component in recklessly. It's common in things like, let me step back before I give you an example. So when a defendant acts negligently, he should be aware that there is this risk and that there is a materially likelihood that something could happen as a result of his conduct. I'm trying to simplify it a little bit, but it probably works better with an example. DWI, right? If you get in a vehicle after you've had some drinks and you drive, certainly you can make it all the way home without anything happening. But you can also drive home and go through a stop sign and hit somebody and injure them or kill them. And this is where this component comes in. The risk, the unjustifiable risk, it's risky to drink and drive. And by getting in the car behind the wheel and doing so will result in possibly a charge of negligently homicide, or it could be involuntary manslaughter. We won't go into those homicide charges, but a lot lesser crime, but you're still going to be charged with killing somebody. It's not murder, but some other level of state of mind exists. If you're texting and driving and you go through an intersection or a red light, you're supposed to stop, and you hit a vehicle and you kill somebody, negligently. This is where this happens most often, is with the traffic-related offenses, and sadly I've represented a couple folks who were just in both of those examples, sadly. So negligently, you're not wanting to commit a crime, but when you take an unjustifiable risk and your behavior is very grossly unaware of what can happen, you can be charged under having a negligently state of mind, or a crime that has that state of mind component. And here's our criminally homicide statute. A person is guilty of criminal negligence, negligent homicide, when with criminal negligence he causes the death of another person. And this is a general intent crime, because you don't need to actually want the result or intend the result. It's just that one state, you're acting with that one state of mind relative to the act. Okay. Hopefully that is clear. Let's talk about a couple others. Examples. And to keep it consistent, this is the definition in New York State, criminal negligence. I won't read it to you. I'll let you guys read through that. The risk, actually, I am going to look at this last paragraph. The risk must be of such a nature and degree that failure to perceive it constitutes a gross deviation from the standard of care. So if you get behind the wheel after you've been drinking, constitutes a gross deviation from the standard of care of a person in a similar position wouldn't have taken. A parent leaves a 2-year-old child alone in the house in order to go out to a bar and have a good time. The child suffocates in his bed during that time because he gets twisted in his blankets. That is an example of negligent homicide. You and some friends are goofing around with a truck. You're doing donuts in a parking lot. You are driving, and one of your friends is in the open cargo area in the back of the truck and is thrown out of the vehicle and sustains serious brain injury. You will be charged with some sort of conduct, negligent, gross deviation from standard care, or possibly a good prosecutor might find a charge that has a reckless component to it. And I'll let you, with those comments I've made, I'll let you go back and look at those two definitions and see how those two fit in. Recklessly, can you get some sort of charge with recklessness or negligent? You are responsible for supervising workers. You permit workers to go up on a scaffold knowing that there are insufficient restraints to prevent falling. You know it's unlikely that anything bad will happen, but the worker has been drinking that day during lunch and then returns to work and falls off the scaffold and dies. Can you be charged? You're supervising workers. Let's say you're the boss. You're supervising workers. You permit workers to go up on a scaffold. What do you think? You could possibly be charged for negligent homicide, because you know they are insufficient, but you kind of know it's unlikely nothing bad will happen. What would a reasonable person do? They'd probably make sure nothing would happen, right? So take a look at the other mental states, see if you can come up with if reckless would work here. Intentional, maybe not. How about knowingly? So think those through when you're looking at your studies. We have 2 more components of mens rea, so we'll be back to cover where there are more than one states of mind in a statute.